or issue come up.
Okay. So, good morning. This is Jason Orm, Chair of the Oregon Board of Accountancy Laws and Rules Committee. Today is Thursday, July 17th, 2025, and the time is 9:03 a.m. Pacific time. And I'm calling the public meeting of the Laws and Rules Committee to order. This Zoom-only meeting is being recorded. We have a quorum to start the meeting. Don't know if we'll have additional guests or members of the committee. We don't expect any other members of the committee at this point. Please make sure you mute your mic when you want to speak. Please either raise your hand so I can see it on the screen or use the raise your hand option in Zoom. Committee members, liaisons, and support staff can ask to speak at any time. For members of the public observing, please use the public comment opportunity for any comment you may have unless specifically called upon. Please don't use the chat option or the chat room for discussions. Should any technical issues arise, we'll pause the meeting until they are resolved. I'll now take a roll call of members and guests. Jason Orm, Chair of the LRC. Amanda?
Amanda Fells, committee member.
Angie?
Here. Oh, Angie, Board Legal Counsel. Sorry.
I was gonna tease Angie, who beats us up on full name and title.
Yeah, I know, right?
Mother's maiden name.
Yeah.
Yep, Angie, I'm here.
I know.
Okay.
Sorry.
Andrew?
I was reading the
Andrew
stuff.
Barlow, board staff, present by Zoom.
Beth?
Beth Spencer, committee member, present by Zoom.
Martin?
Martin Puccioni, Executive Director and Senior Advisor to the LRC.
Sherry?
Sherry McPherson, committee member, present.
Quinn?
Quinn Stoddard, board staff.
Thank you. Is there anyone that I missed? I don't see any other people on the call. Quinn says we are good. Has everyone had the opportunity to review the draft agenda? We got a draft from Martin and from Quinn. I believe that they are the same. There is one modification that we'd like to make. Under item 4, there are 2 items with regard to CPE rules, one on proration, one on credit for committee service. We would like to tuck in another one, call it D sub 1 if you want, and that is CPE for instructors of 1 to 200 level accounting courses. Are there any other adjustments to the agenda? Hearing none, I would accept a motion to approve the agenda. And remember, when we move second and vote, full name.
Sherry
Amanda-
McPherson. Oops. Go ahead.
I was going to say Amanda Fells, so moved.
Okay, second.
Sherry McPherson, so moved.
Okay, any discussion? All right, starting with Amanda, yay or nay? Stating your full name again.
Amanda Fells, yay.
Beth?
Beth Spencer, yay.
Sherry?
Sherry McPherson, yay.
Jason Orm, yay. Motion passes. Let's see. There are no members of the public here, so I'm going to skip the public comment. Both Angie, I put this as Martin and I, but I'm going to throw Angie in here too. Martin, do you want to give just an update of conversations that have been had with Angie and the board with Haley since our last LRC that's given the direction for where we are today and where we're continuing to go?
Yes, I can do that. And I do believe, Jason, that and the members of the committee, that would overlap a bit with item number 5. So I'm hoping I'm going to cover with what I'm going to say next, the types of things you would hope me to cover, Jason.
Okay.
But in essence, folks, I'm sure that you remember, whether it's with, appreciation or beautiful memories or a sense of trauma, our discussions around private equity in this committee and APS. Essentially, we have taken a deliberate step away from that piece because after the last LRC meeting, it became clear that we needed a little bit more direction on certain issues in that space from the board. So there's two things that happened in response. One is that I worked with our board chair to schedule a special board meeting on Monday, August 12, which happens to be 3-4 days before our August 15 Laws and Rules Committee meeting. And so in order to essentially use our time more wisely, since we really have a dual assignment from the board. One is at the level of rule to tackle a whole bunch of rule development that ultimately needs to culminate in a final product no later than the December board meeting. But we have a ton of lifts there, not exclusive to, but primarily evolving around implementation of our main bill, Senate Bill 797 with the new licensure pathways. But really effectively needing to do comprehensive rules updates, including that piece and beyond that we would get started on that piece and start delving into it to use our time here wisely today rather than spinning our wheels a little bit more on private equity and APS. And then essentially, so we want to try to get some momentum on the rules piece while we're working board side on a little bit more direction and guidance on the P and APS. I also want to say that because we have really good partnerships, there is also an event tomorrow that I did not organize or put together, where we're really leaning on the Washington Board of Accountancy. The Washington Board of Accountancy has a regular board meeting tomorrow, and their agenda is primarily focused on private equity and APS pieces, and they have, from what I understand, to be a panel discussion, but really an interactive, a chance for their board to interact with folks that either are working in the PE space or are experts on the PE space, because they're trying to figure out what they're going to do as well. And so the plan is for, since it's a public meeting, right, is for folks like Angie and I think Jason, you're trying to join us as well.
Yes.
Angie, Jason, and I were planning on essentially scooting into that public meeting and just be listening and learning from the types of questions that they have, and it may also help us formulate, quite frankly, because one of the things I will try to do with Jason and with Angie is to formulate essentially a very specific set of questions that we hope to have the board answer on August 12. We have about a 90-minute meeting scheduled with the board on August 12. And hopefully that will help us get to a clearer place in terms of board expectations and guidance for us in that area. So that's kind of, I hope that makes sense. I'll stop there and see if there's questions and ask you, Jason, first. Is that
Martin, it's
rough?
August,
What
it's
we
August
need to cover?
11th.
Thank you,
What's
Angie.
11th?
August
Oh,
11th.
it's the 11th. Sorry,
I
it's
just
whatever
looked
the
at my
Monday is.
calendar to confirm, and it's on the 11th. Angie spoke first. I
Okay.
wanted to make sure I was
Sorry.
going to be at the right spot at the right time.
Yeah, it's Monday, August 11th. Sorry, whatever the Monday is. I should have said Monday, not Friday. So it's a Monday-Friday thing. So our LRC is on Friday, and Friday, August 15. That part I have an easy time remembering because that's on my birthday. It's the board meeting that I struggle with. So, all right. So it's on the 11th then, whatever the Monday is. So thank you for that date correction.
So if we were having that LRC in person, we could celebrate more easily his birthday. Now, I could probably get away with buying a cupcake for Martin and Angie and be safe under the rules, but
I'm not worried about it. My staff tends to be very sophisticated with what are called, I'm not even sure what that stands for, GIFs. And so I'm pretty sure that either Quinn or Andrew will come up with some kind of a virtual cupcake thing for that meeting.
I'm sure it's already in process. Okay, so we'll have more on private equity. It's going to be interesting to see what the Washington board does, but that's why after we got through what we did the last LRC, Angie came back and said, okay, I'm not sure what to do here. And the board's still trying to figure it out too. So we're going to go after some of the 797 things, and then we still have the new licensure standard, et cetera, and we'll just kind of keep moving through them. But what we're doing today needs to be done, but it's hopefully, as Martin said, easier things. And Angie, you put a bunch of information together for this. And so I'm going to rely on you for a number of things. But one, let's go with the inactive and start there. So we made the decision in 797 to put inactive in. And now we need that they can't practice except if it's in rule. So now the question is, what do we put in rule? And Angie, what I remember you writing is what I remember us discussing, and that is, shouldn't they be able to do what we're allowing retireds to do, which is effectively, they could work for me as a staff person, can't sign off, supervised by a CPA, but that be a staff person. Is that recollection correct as far as everybody else?
So what we had talked about before, before we did the statutory change. So what the statute says currently on inactives wasn't sort of like in alignment with what we were sort of like doing in practice. And so basically what we did was we clarified the statute now. So the statute is very clear on like, it can't be, obviously a solar practitioner, like that sort of stuff, like, unless it's permitted by the board for like specific reasons or something like that. But there's, we sort of like made it so like we can do more in rule to allow it, because what had happened before when they changed the statute on this was that they did want to allow inactives to do certain things, but they didn't, it wasn't, sometimes when we do this statutory fix stuff, what we hope happens and what happens are different things. And so I think that's what happened the last time. So now we have this part of the statute happened in the way we wanted it to happen. And so we are good there. So now we have the ability to put in rule, like kind of like what we want to do. Now we did that big pass through on the retired stuff before. So what I gave you, right, was this sort of like more like high level, here's the issue. And for inactive, I put here in the email that you got, in the text of the email, that's what the statutory language reads. And then if you open up the document I gave you and you go to that rule, I sort of did, so what I tried to do initially was like, I was like, I'm just going to go through and just do a first pass at all the rules, which is what Martin asked me to do. And I spent so much time like trying, and there's just so much. So I did as much as I could in the time I had. And then I also kind of like just put in that document sometimes some notes and some thoughts I had. And then, basically kind of like also looking at it from a standpoint of like, since we are doing these, we should, fix the little technical edit things that we need to fix anyways. And in addition to that, so what I also tried to do in that document was like, anytime that rule itself was changed by statute, I tried to put the language of the Senate Bill 797 in anytime that was there. So it was easy for you to reference like this statutory change affects this rule, so that you could see it all in one place. So what I think we need to do on inactive, right, is like, so we obviously need to change the language. And I think there was a little bit of a go back and forth before, on like what we really should do with inactives and whether or not to allow them to practice or not. And then, you know, we basically kind of were like, well, we can't really do much anyways until we get the statute fixed. So let's pause this conversation and have it after the statute is fixed. So that was just like my note that I put in there. Like, so if you go into the Word document and you go to that rule, that's what Jason is talking about. So currently right now, that rule, the inactive rule is both inactive and retired. They're all under one rule. So we could separate them out, make it two separate, you know, and then also in looking at that, we had already redone the retired statute, statute rule. But I revamped it just to make it a little more cleaner, just to like make it like, this is what a retired can do. This is what a retired can't do. Instead of having it, because it was sort of like, I don't know what happened before, but we're trying to just streamline it. So I guess first take a look at that and then think like, is that what we want for inactives? Like sort of like similar things there. And if that is true, you know, we could either separate it out or not. Sorry, Martin, go ahead.
No, no apologies. I think this was a great introduction. I just want to do a piggyback on it a tiny bit, right? Because as I understand it, and Angie, please disagree with me if this does not align with your recollection. I view this inactive piece kind of really as consisting of two buckets. One is, to me, the more straightforward bucket, and the one that your comments focused on primarily, which is, hey, we needed to have a statutory change in order to be able to do anything with inactives. And so really the main part of the conversation with this committee is, are we trying to frame what an inactive can do largely around what we're doing with retireds? And that's true, except that there is also a little bit of a second bucket, and that's a little bit of a more, if you will, uncomfortable bucket. And that is one where we have no alignment by definition with the retired status, right? And that is, and I'll phrase this very carefully since we're in a public meeting, but let me just put it out this way, right? We are one of the very few, if not the only states that have a albeit reduced CPE requirement that pertains to inactive status, and therefore also a broader permission, right? Because in most jurisdictions that you go to, right, inactive status literally means not active, like you're not doing a thing. And we've always tried to create a much broader space for a variety of historical reasons. And inside that space is something where we need to think beyond what we've done with retired status and essentially get to the place that I think all of us know is there, and it's just kind of assumed, but we need to make sure that we solidify it, because I have not heard a desire from the board to make a policy change there. But effectively, what's happened here is that we are allowing folks in inactive status that are not in public accounting firms to be compensated and to use their, if you will, their skills, including their CPA skills, as long as they work for a essentially single employer, right? So we have inactive status licensees, right, that, for example, could work in, let's say, a CFO position, right, either for a nonprofit or a private company. And essentially, I will simply say that while that has historically been allowed by the board, kind of the foundation for it in statute and rule has been, I'm just going to use a term that Angie will probably not like, slightly awkward. And I think that one of the goals for us is, I'm not hearing a desire to rattle with that place, but I think what we need is more clarity or a foundation that that's okay. Does that, and Angie, did that give you too much grief with what I just pointed out, or is that an okay thing to say the way I just phrased this?
Yeah, that's it. Yeah, and so that is the other sort of like hard part, right? With the the totally separate, yeah, so you're right, there are the sort of the two buckets. You have the people, before, we were basically like, if you were inactive, you couldn't work in a firm, basically is what it was. That was what it was before. On the other flip side, right, was that the board was wanting to sort of open that up and look at how that could work, basically saying, you know, why are we just saying if you have an inactive CPA license, you can't even, you know, be an HR person? So that was the push
Mhm.
there. And then on the other side, right, which is what the board hasn't, you know, really talked about, but it does give me the most heartburn of this whole thing, right, is that you have all of these people that are inactive, you know, in these positions, and it's not super clear how we regulate that, what we do with it, do we care, you know, so yeah, so we definitely need to clean that up too.
Sherry, you're on mute. I can see you're talking, but you're on mute.
My apologies. Angie, when you mentioned that, so just for clarification, you're talking about those folks in industry, et cetera.
Right.
Yeah,
Yes.
and just some historical perspective, you know, from my standpoint, I know that's not new, and that's
Yeah, it's not new, no, for
that's
sure.
way,
No.
I mean, that's way before Martin was here the first time. I remember when we had LRC, and when Martin was here the first time, Amanda, you weren't in the room, Stu was. We had a lot of very extensive conversations around this. I'm not sure by opening up that, I think we would be opening up Pandora's box, in my opinion. You know, folks have said in, you know, with inactive license in industry, and I'm just going to call nonprofits all industry because they're not firms, right? Or they've set those for a long, long time. I'm not sure what you would accomplish. Just kind of thinking out
Well,
loud.
just to be really clear, Sherry, the issue here is not whether we're trying to change policy.
Right.
The issue is that policy has been on a, let's just say, less than ideal foundation in statute and rule, and we're trying to essentially firm up the foundation.
Yeah.
I
Okay.
think what we're trying to do.
Okay.
Right, well, also too, right, I wanted though also to open up the conversation of like, you know, because there was some back and forth around that, like, so do you want to continue, like, it sounds like, I mean, for Sherry, right, she wants to continue that, right, and that's totally fine too. I'm not saying we need to change it, I'm just saying, like, you know, this is the time, we have the ability now to do either way, right?
Right.
So yes, it has always been that way. Whether or not we could have been doing the way we were doing it is
Yeah.
a question that's moot now because we fixed it, right? So we can do it now. And so just trying to make sure we have a rule that helps, because from a regulatory standpoint, for this side of that, the hardest part about that in general, right? Like, which, like, if, you know, from like, if you're looking at it from a regulatory standpoint and just like for me, like, of like, what's the easiest case to prove, right? Is the easiest
Right.
case to prove, right, is to say inactives can't practice, right? That's just an easier way, period, right? Obviously, that's not what the board wants or what you guys want. So like, we need to like figure out like what that looks like going forward.
Yeah. What practice looks like. That's yeah.
Yes.
Yeah. And I remember, you know, when we worked on inactive and retired those many years back, I mean, they were some very, I mean, we had some very serious and thoughtful and thought-provoking conversations around all of them, you know. So I very much appreciate the conversation around it and just that clarification too, because it is so important. I want to make sure I'm not understanding. And I've got this light flickering in the back, and all of a sudden it's like, you know, what's going on back there? So for just a moment, you know, so I just wanted to make sure that everything was on point here.
Yeah.
So I appreciate it.
So to me, there's an issue out here with the industry piece to make sure that we bring rule in line with policy, what's been done. And as I look at the rule that Angie sent out, there's a part of me that just wants to, I mean, we talked about having it be like the retired. Can we do that under 6D of 801-010-0120. 6D says a retired licensee may hold ownership and an interest in a CPA firm. That would probably be a no. We don't want an inactive to hold ownership. Be employed by a public accounting firm performing any work that someone without a CPA or PA license is entitled to perform in a public accounting firm. Work of an active licensee must be supervised by an active licensee. Same language.
Jason, would you mind sharing your screen on that?
I would love to, except I am running Zoom from my iPad because it's easier.
Okay.
And I'm reading it from one of my 3 screens on my computer. This attached to Angie's email.
Right.
It's the Word doc that was attached to Angie's email. So Sherry, I would love to, but I need more tech support than I have in my office.
No, it's okay. I'm reading it on my phone, so.
Okay. Oh, you're, yeah.
I'm on an iPad phone, so.
Yeah, put your readers on. The one thing that doesn't cover is, and I don't know why we didn't do that on retirees.
Because I don't think the idea, right, was to allow a retired person to go be I mean, I think they could still. I mean, honestly, I think what that would come down to, right? Like, I don't know. I guess what the bigger question I've always had on this whole thing of like what we do on the non-firm side, right? When people are inactive is like, do you need a CPA license to do the work, right? Yeah. And so I think that's the thing. Like, so if somebody, like, basically, I think for a retired as well, right? Like the whole thing, what it comes down to, I feel like almost is just like, how do they hold themselves out, right? And so for this, for retired, like regardless of on retired, if you are doing anything anywhere and you want to put CPA after your name, you have to put retired CPA, right? Or CPA retired. It's the other way around. And so, you know, we could sort of, and what is the statute actually talked about the inactive, no matter what, right?
Can I try this a little bit? So I think that the reason where we need to be careful is, right, there are similarities between what we're trying to do with inactive status and retired status with respect to what they have in common is that we're trying to use the retired framework in a similar way for inactives in terms of opening up the ability for an inactive person to also be inside a public accounting firm, which was previously essentially the no-go zone. That is one of the things we're trying to accomplish. And I think probably one of the simpler questions that we can test out pretty quickly with this group is this group comfortable with, for purposes of what happens inside a registered public accounting firm, that we essentially use a similar policy framework for the inactives as we did for the retireds, right? That to me is kind of a standalone question that we should be able to resolve pretty easily. Outside that piece is where we need to be really careful about getting, trying to make too many similarities between retired and inactives. And the reason for that is that retired status has historically also come with, hey, you're not really practicing unless you're a volunteer. You don't get to do anything for compensation, right? We haven't had those restrictions in inactive status, right? You could be out there and, do compensated work in the private sector using your CPA skills essentially for a single client, i.e. your employer, right? So that was always really different between inactive status and being able to do compensated work where, quite frankly, the expectation is that they would use their CPA skills. And the only really restriction on the inactive status is that they wouldn't do it with multiple clients, because the board then saw that, well, once you start taking in multiple clients, you're effectively practicing, public accountancy. right? You're not just serving a single employer, then you're effectively, doing the whole enchilada for which you need to, for which you would need an active level license. Not the cleanest construct, but that's what we've historically done.
So may I chime in a moment on that? So I'm going to use just a yearly term. I'm going to say approximate. So if I say 10 years from now on, we could all be on the same page. I'm saying approximate. And the reason I'm saying that, 3 years that Martin's been back, plus 5 years when Martin wasn't there. And then those couple of years we were working on laws and rules before. So if we go back over 10 years, right? Martin, I'm agreeing with you on everything. The only thing that I would say that from my view is different is before we worked on laws and rules about 10 years ago, for many years, retired CPAs, and there wasn't that formal status in the same way, right? But retired CPAs did work in firms under other CPAs for many years, like they'd come in and help during tax season and so forth. If you go way back.
You mean without a license? They simply were
Yeah.
retired.
Yes, so they couldn't sign off, they couldn't do all those things. I'm just gonna say, we use the term, we tightened up, changed a lot of that stuff about 10 years ago, give or take. But before that, and that was what really took a lot of people by surprise too, because they had been doing that for a long time. And part of that process too, about 10 years ago, that's how we ended up with those matrices. The matrices, I guess I'd say, which I have been forever appreciative of, because they really helped frame out the retired and the inactive at that point, because there were so many questions. And so anyway, and part of that allowed people to be able to work on HR in the firm without an active permit to practice, for example. But anyway, that's what I was reflecting back and just thinking about a lot of the comments I had around retired. I would say, in my opinion, keeping it simple. I don't feel like we're an outlier on the industry side. You're going to know that better than me as a licensing expert, but in many ways, I think there's also a sense of public protection about that, because you have people with skill sets that are out there. They may be using that, but as long as they're not crossing that line where they're working with multiple clients, if they are even like a contract controller, I think all of a sudden you're in you're in a different realm, in my opinion. I like the way you frame things out. Thank you. I hope I helped.
One of the things we talked about at one point when Ray was here, and I'm not trying to confuse the issue, I just want to make sure that it doesn't get lost in it. One of the things we talked about was at one point with this whole inactive side of things was another option, right, is to say you do have to have an active license, like to do any of this stuff, but make it easier for those people that are currently inactive to come back into active status, right? Like lessen the requirements to get them back into where they needed to go, or make it easier for like a short period of time to allow anybody right now that has inactive that would need to come back to inactive if they wanted to, right? To do that.
Come back to active if they wanted to.
Right.
Yeah.
And then in general, right, like maybe like we look at our CPE, which we're going to be looking at anyways, and see like, are we, look at the overall CPE structure and see if there's a way to like make that easier or whatever to keep people in active status versus having so many people go inactive, because I would think we are, and then, right, and then for inactive people that are truly inactive, they would have no CPE requirement, because that's what you normally see for most licensing agencies, right? A person is inactive, it means they can't practice and they don't have to do CPE. So like I keep an inactive license in Colorado because I don't want to give it up, but like, but I don't do CPE, I don't, whatever, but I just keep it there in case I ever decide I want to move back to Colorado. Martin pushes me over the edge and I go back. I'm just kidding. So that's like, so that's just a topic to throw out there to consider. Is that something we talked about when Ray was here the last time we talked about inactive status? So just wanted to put that out there as a. It's
true that we are definitely outliers. And in fact, yesterday, and maybe Angie, you knew this all along, maybe there's others here who knew this all along, but I really for me, very hard conversation yesterday with the CEO of NASBA and a number of my colleagues, during which I realized how much of an outlier we were. Because I thought, just from a simple regulatory perspective, right? Just talking about the concept of, hey, once you're licensed, and you don't just get to turn off whether you are a licensee or not by means of whether you use your designation, right? Regardless of whether it's in a public accounting firm or, in the private sector or at a nonprofit, right? And then I'm hearing loud and clear that there are states where exactly that on-off switch is the law, right? Where literally, if you decide not, even though you have a CPA license, if you don't say CPA, you basically say, this is work that I'm doing that is not governed. I'm not doing that work as a CPA. The professional standards don't apply, right? And so I'm not suggesting we go there, please. But really not suggesting we go there. But it does mean that we are a bit of a bit of an outlier in all of that, and I'm a little worried that I do think we need to openly talk about whether this committee would recommend to the board that we should just clean this up by saying, can we just basically, I'm going to use a different term, grandfather the inactives that are working in private industry now and pull them over into active status and kind of align more with other jurisdictions that inactive really means you're not doing anything. Because that's certainly the other policy option, is that you just bring them all in, transition them all over, as opposed to having that, right? So you bring them all in, bring them into active status and say, you can keep on doing what you're doing, but you now need to do it as an active level CPA, and you make it easy on them.
So what I worry about a little bit with that, just thinking out loud, is that, right now is that inactive, they're still kind of under the board, right?
They are.
But if they were all brought over, because so many people were inactive for many years too, if they were all brought back in, then they would have the 80 hours of education and so forth. I think that you'd have a lot of people then giving it up completely. And
No, I think Martin was saying make it easy though, right? Like make it easy for
Well,
them.
So afterwards,
going
I think what you're
forward,
talking
you
about
should.
afterwards, going forward,
Oh,
they will
yeah.
have to renew at an active level, pay higher level fees, take more
Yeah.
CPE and all that stuff.
Yeah,
right?
that would still make Oregon an outlier.
Yes.
Because when people are in private practice, in most jurisdictions, it's no longer considered public accounting. So the fact that we have all of
Mm.
these statements that call it public accounting is also unique.
Yes.
So I wouldn't encourage us making it harder for people in industry.
Well, part of the problem too is that 80, oh, Jason, you go first and then I'll be quiet.
One question, and then it rolls back in here. So I'm reading rule, and it says that under inactive status, that they have to satisfy the continuing education requirement as provided in OER 801, 040, 0010, which is the 80-hour requirement.
It's a reduced requirement
The
for
reduced
inactives.
requirement for inactive. So they have, I think, 34 right now, if I remember
Where
correctly.
is that stated?
Right.
It's in there. It's when you go to the CPE part.
It's the
Okay.
reference to that.
I'm not dipping down far enough into it.
Yeah.
Because the CPE part just references the standard CPE as must satisfy continuing education as provided in.
Yeah, and so that's just sending you to that rule, and then in that rule, there's different requirements of CPE for different type of license.
Okay.
Yeah. I mean, this conversation has been interesting, Angie, what you said sort of, and Ray, reminding us about Ray, there is a reason to maybe not make inactives the same as retired because they are in a different situation in life, right? It's a different scenario. The retireds, we've been told they're people who want to come back and help prepare taxes or do seasonal work or whatever. And inactives, it's you're saying, I don't want to be a practicing public accountant anymore. So I could see us saying that's okay. If you want to work in a firm, you're going to have to get active. Because here are some scenarios that come to me with a large national firm. We don't just do public accounting. So we have people who want to go inactive and go work in our digital, where they're going to develop software, right? Well, we wouldn't necessarily have an active CPA supervising them. I mean, it's an edge case, but it's just something to think about as firms keep combining. Like, I just don't want us to create another administrative nightmare that we can't handle. The other thing is, I love that inactive licensees may not hold ownership, because boy, they want to, right? They want to. And it's like, no, you're going to be an active CPA in a CPA firm. So I'm just wondering if we do want to treat inactive still a little different. Like, hey, if you want to work in a firm and you're inactive, there's no reason for you not to be active unless you're old enough to be retired.
So,
What do you,
yeah, I mean, I think that and so maybe it just does need to be totally I think the reason I remember the conversation about the supervision requirement for the retired was that, again, what ends up happening, right, from a in practice standpoint, and what we heard, I can't remember if it was the board talking about it or you guys talking about it, was the whole issue of like, you know, it's hard if you've been like, so say you're in a firm, right? Like you've already been there. It's going to be very different. Like if you're going to hire somebody on new, right, that's inactive and you're hiring them for HR, you know, that's the best case scenario, right? Like that's like nothing's going to probably go wrong there. Versus if you have somebody who's at a firm and has been at a firm, right, and then decides they want to go inactive and then do HR, but you know, they still see their clients every once in a while, you know, like they still see like people they've had relationships with, and then suddenly
that is real.
Yeah.
That is real. We have had that happen, not in Oregon, but we have had people just say, well, I'm retiring in 6 months. I just changed my license to inactive because they weren't old enough or whatever. It's like, you can't do that. You're serving clients. So it is a risk.
Yeah. So I think that's why before, right, it was very much like you can't be inactive at a firm because there's just more risk there. So I don't know how you, without saying they have to be supervised, and I guess we could define supervision differently, right? Like it's like supervised in the respect that somebody is going to make sure this person is not like, you know,
Practicing public accountancy without
Right.
improperly. Yeah.
Because I think that's where, you know, and then you're putting another person on the hook for somebody else's behavior, and it's just like, you know, so I think that's, I feel like before that's kind of like where we always like sort of like went back to like from like sort of like the sort of regulatory standpoint of like it makes it really hard to do.
So thank you for pointing me to the right area of statute. I missed the reduced CPE. I didn't read far enough or in rule. So really the difference is 32 hours versus 80 hours of CPE.
And a different renewal fee.
Could I share something?
Please.
Okay, I'm going to share it. We'll see how this goes. I got to find the right screen. Yeah, here we go. Okay. This is a lot of caveats here, but sorry, let's move you guys over here. So if we did want to allow it in the accounting firm, I mean, we could get very, very sorry, but that's not even readable.
It is for me.
Oh, okay.
Yeah, it's great.
I never assume as the older I get, it's harder and harder to read. Okay.
I resemble that remark.
Yeah. Yeah. If the licensee is employed by an accounting firm, they're only performing any work that someone without a CPA, oh, wait, no. Must be supervised by an active licensee. That's confusing. Sorry, I completely missed the, no, that's it. So that way you could carve it out to just be in the accounting area.
Which means that if somebody is, you know, to get to the stuff that's been driving the board crazy for a longer time, because we've had these very painful things going back well over a decade that I remember, you know, of these outlier cases coming in and saying, hey, not serving clients anymore. I'm going to run HR, you know, I'm now the recruiter, or I'm now the person who oversees IT or AI stuff, right? And I'm no
Right.
longer having any direct client contact, right?
Right.
And our response historically has been, sorry, you have to be an actively licensed CPA to do any kind of work
Yeah.
in a public accounting firm, right? And so I think what
Yeah.
you're trying to do here is carve out that for those truly behind the scenes kind of admin IT type roles, that they wouldn't have to be supervised by an active level licensee, but they could do it because it's part of what someone without a license could perform. But
Yes.
if they get into the other stuff,
Yeah.
around the accounting or attestation skills, then they have to be supervised by an active level CPA.
So I'm
Martin,
gonna
That's
say you
it.
probably don't want. So the hard part here is like that would be come down to like then, like so the sort of pushback you might see on this, right, is like then why have a license? Why would anybody keep a, because like in theory, what you're saying now is that they can basically do a bunch of stuff that we were saying before that they couldn't do. So like before we're saying, right, you basically can't use your CPA or accounting knowledge if you're going to be at a firm. What we're trying to do, right, is to say like you don't get to do any of that. You get to.
Oh, are we trying to do that? I thought we were trying to make it so that they were like the retireds who could do the stuff. Because if we're not trying to do that, then let's not.
Well, it's a policy question, right? So the policy
Yeah.
question is, do we really want to emulate the retired stuff? Or is the solution for the inactives to say, we will open up the space for you to be inside a public accounting firm if it truly is this admin stuff, the stuff that's been driving the board crazy.
The
You're
retired though
running
does.
IT, if you're running HR, that it
Got it.
doesn't make any sense for us to require you to be an actively licensed CPA.
Got it.
So the
Yeah, that
retired
makes
though
sense.
is the same in the respect that they are not allowed to do anything. So it's the retired says you can be employed by a public accounting firm performing any work that somebody without a CPA or PA license is entitled to perform in a public accounting firm. And the only reason why we did the work of a retired licensee must be supervised by an active licensee is because of that hiccup, right? Of like, you have somebody who's suddenly retired and, they're there only to do HR stuff, but then, they end up chatting with their clients or like whatever.
No, we did that to allow them to prepare tax returns during busy season, is my understanding. Was that right, Amanda? Yeah,
I
I think.
that doesn't sound familiar to me.
That was
Am
my
I not
understanding, is that the idea is that if somebody retired and they were coming back, they could work supervised.
Yes.
Okay. Okay. So maybe
but-
I rewrote it wrong.
Okay.
Sure.
Yeah.
Supervised.
Well, and non-CPAs can prepare tax returns.
Yeah.
Right?
Okay.
Yep.
Yeah. Again, you just
Yeah.
can't sign them, right?
Right.
They can't
That's
sign.
yeah.
Martin,
Ms. Sherry.
Martin, what you were just describing, I feel like the answers, we work through that before the answers are listed in that matrix for inactive and that matrix for retired. I feel like there's a lot of our answers there. Does that make sense? We were talking about what can an inactive in a firm do? I mean, we said HR, we said some other things.
Well, not on the matrix, because the matrix wouldn't allow them to be in a public accounting firm at all.
Okay, it's been a while since I've read the matrix. There was, maybe it was, I feel like there's an HR piece or a personnel piece on either retired or inactive. I thought there was one on inactive, but I could be wrong. I haven't read it for a while. I'm gonna see if I can find it.
Well, Sherry, while you're looking, let me bring us back up above the weeds for just a minute.
Sure.
What I'm hearing in this discussion is, if you're inactive and you want to prepare tax returns in a firm, just take the extra 48 hours of CPA, pay the higher fee, and be done. If you're inactive and want to fill a role of an HR person in a firm or IT person of a firm or something that is not the public accounting practice, okay, we'll let you work in a firm. Is that what I'm hearing?
Can you say that again, Jason?
Yeah.
So I'm inactive. If I want to be working at TKW and I want to be helping with the assurance side of the practice and, audits, reviews, comps, issuing financial statements, or I want to be preparing tax returns and talking to clients, just get your 48 hours of CPE, Jason, pay the higher fee and be an active licensee. But if they want me to be, Jason, just be the HR director and head of IT, so we don't have to handle all this administrivia, I'm still working for a public accounting firm, but I can do that. And Jason, you can't talk to your clients anymore unless they just happen to be in the lobby and you walk through and say hi. Is
I like
that the
that.
direction we're going? That's what I'm hearing.
And the idea behind that would be because to take the position that an inactive licensee can do anything that an unlicensed person can do is just too muddy, right? It's just too unclear and too hard to enforce because it's too vague. Like those boundaries aren't clean, right? Is that kind of the
But
thinking?
I'm not sure how to write what Jason just described.
But you're a master at that, Angie.
No, because I've been trying to write this whole time, right? Like,
So
yeah,
I think what I would say, and it's difficult because now we're putting in definitions, but maybe if you grabbed, we carve out inactives and say they can't be in public accounting unless rule says otherwise. Why not have a one-liner that says an inactive licensee may be employed by a public accounting firm in the following roles: human resources, Beth twitched, human resources, and just a list.
And that's where that matrix comes in, Jason, because it had things like trustee and that sort of thing. I cannot find it. It's probably because I'm looking on my phone.
Well,
But-
yeah, matrices. I don't love having things that are not in rule that people can
No,
refer
I'm not
to.
saying
Oh,
we should use them.
okay,
I'm saying we did the work
Yeah.
and they've been in use, 8 years now, where there was like always this, hey, here's the matrix, now call the state board. That's how we would use them. And the reason the laws and rules worked on them before when Martin was there was it gave those pieces where, hey, and if you don't see it here, you you must call the board because you have to make sure you're in compliance. But I've just,
what about the concept of you may be employed? I hesitate with the list. The only reason you got the face, Jason, is in 20 years, what additional departments do we not know? And can we try to write this so we don't have to rewrite it every 5 years when society changes completely again? But what about just saying, hey, you can be employed by a public accounting firm as an inactive CPA, as long as you're not doing any of the work contained in our definition of the practice of public accountancy. Now, would we consider management consulting or anything like that to relate to HR or anything like that?
that's the hard part, right? Like, that's the hard part with our definition.
Okay.
And that, then in theory, right, they can't do the preparation of tax returns.
Right, which I think we're okay with, maybe, because retired can, but if you're inactive, go get it active.
I just realized when we were talking about this today, I got to fix the retired thing on that, because that's not what it says. So, so we'll fix that. That's fine. That's why we have these conversations, right? Yeah, so that's exactly what I just wrote after the first part was like, basically like, you can work at a firm if you're not practicing public accountancy, but then you're going back to that, which is fine, right? Like, we can just say, you can't practice public accountancy and leave it at that.
I think if it would only come before the board if there were a complaint or an issue that the board needed to do. And then I think the board could use judgment to determine, well, this isn't public accountancy when they're consulting on digital software implementation for, I
Right.
don't know, non-financial purposes.
So, Angie, what is the definition of public accounting in Oregon statute and rule?
Well, in rule, it's very long.
And
Okay.
very broad.
And very broad. So, and I bring it back to this because it goes to the private equity discussion that we've had and will continue to have. So I agree with you, Beth. I'd love to craft something that's good until well beyond I'm on this earth. But the profession is going to continue to morph. 30
Yeah.
years ago, I never would have imagined us doing certain things.
Okay.
I would like it to stay, fresh for more than a year and a half. But
No.
I don't know how to, we could do it and just say, if you're practicing public accounting in a firm, you got to be licensed. Otherwise, you're okay. But Martin, regulator, and Angie, counsel, is that comfortable?
Well, all I will say is I appreciate you bringing up private equity because I have been thinking about it in the back of my mind, right? The way we're talking about this right now is about what an inactive licensee can do in a public accounting firm. What PE challenges us is to basically say that especially in the tax and advisory space, right? There, you now have firms migrating towards the declaration that this is not a CPA firm. It is owned by PE, which means that, quite frankly, we wouldn't be able to tell. Short of having sometimes license requirements when you actually file a tax return, right? We couldn't even, I don't know that our rules would reach the PE space that is not inside a public accounting firm.
That's
So
what's,
Martin, let me nudge on that just a minute. Y'all know I'm a tax guy. That's all I do. Okay, on rare occasion, I read footnotes on financial statements to make sure they're okay. But I practicing public accounting according to the PE. Ignore my licensure for a minute. Am I practicing public accounting in the state of Oregon according to what PE thinks? I don't think I am based on how they're structuring things. So
That's what they want anyway.
that's what
Yeah.
they want. So then if we do that with the inactive licensees, cool. They can
Yeah.
prepare returns, they can do all that work, they can interact with clients. Everything that I'm doing, our staff that are not licensed will ask questions of clients and that sort of thing for more data, et cetera, because they're supervised. So I cracked this open to the broader question, but it's that broader question that we're going to continue to work on.
yeah. These rules are going to have to be adjusted over and over because the other thing, AI, what that looks like as compared to 18 months ago or 2 years ago, who knows what 2 years or 5 years from now looks like too. So
where are we landing here?
yeah.
That's my question. So let me bring us back to generals for just a minute. It feels like there's agreement that if you're practicing public accounting, and I use that term with both a sense of humor and for real, if you practice public accounting in a public accounting firm, go get the other 48 hours and be active. Everybody who thinks that that's where we are, raise your hand.
And you're okay.
Okay. So okay, Sherry's got hesitation.
Well, it's not hesitation. I'm just trying to make sure that I am following the definition Like, we're all on the same page about that definition, right?
Okay, I'm getting to the definition now.
Okay.
And that's the real question. So everybody, if you're practicing public accounting, yep, go be active.
Yeah,
If you're doing HR at a public accounting firm, you can be inactive and we're fine.
Well, and so like
Yeah.
actually looking at the definition itself, right? So what it lists out in the practice of public accountancy, actually, I feel like there were other things in here before, but I guess maybe I was making them up. It says by another person, professional services of accounting, tax, personal financial planning, litigation support services, and those professional services for which standards are promulgated. So and then it lists out all the promulgation stuff. So like, you know, the standards that include financial standards board, like that stuff. So
that's a fairly broad definition, going back to how private equity is doing what it's doing. I don't know. But do we tie it to that definition that's already in statute and say, you can work in a public accounting firm, but not providing services? There's got to be better language than what I just used, Angie, but not providing services in an area that is public accounting is defined in yada, yada. For example, you could work as a director of HR and maybe give examples, a couple. That ties it back to that definition, which Beth, I think is where you were going, and Sherry, I think is where you were kind of going. It's an existing definition in rule and law. It gives the board some breathing. It gives the board bedrock to say, okay, here's what works and here's what doesn't. It also gives the board some flexibility to say, okay, things have changed a little bit. And while we've never seen this AI version of whatever, we believe that tucks under this in public accounting. I mean, it provides a little bit of it provides some certainty with flexibility as things change.
And then
Comments?
Sorry.
Let's see, Beth started first. Sherry was a close second. So go Beth and then Sherry.
I'm good with that as long as then we keep the element of you can do this in private practice for one business entity. Because those PE firms, I think then in theory fall into that. I don't know. No, they don't, Angie. So, but they're not public. They're just out. We don't have a way to capture that.
No.
Okay, never mind.
okay.
Oh, go ahead, Sherry, because I said, nope, Sherry, I called on you next and then I started to speak.
Well, I had two things. I was going to say, I like the idea of detailing out, even to the point in rule of where you'd say, let's just say light words, not included would be, personnel, HR, right? I liked that because in a way, that's what that separate matrix was having to solve the problem of. So I like that clarification. I don't want to call out a name in public, but that really hit me there when we start talking about what could they do. And I've seen Angie and Martin shake their head and, we were getting all excited with a positive there. There is a very big national company that has always done a lot of these things, and they're not really considered a CPA firm. And they're expanding. And I don't want to say anything more than that, but I question about, okay, how does a structure like that fall in? Because they're not exactly PE, but it gets back to the individual licensee, I guess, at the end of the day, in many ways. They're not doing a test.
So this for inactives, right? We're not touching for right now, right? All we're talking about right now, we're gonna get into the other. We're just saying you can work in a firm.
Right.
So I think
I didn't mean to take us down another pathway. I was just thinking about that for this firm where we were talking about this for the firm a moment ago. And
I actually think that's a really good pathway, because what if we don't, okay, this could be crazy. So what if we don't say for a firm? For an employer other than a private practice for one client. And then it wouldn't be limited to public accounting firms, but it would also include the PE.
Or other commercial entities.
I don't know, just an idea.
Well, I'm-
It's a good idea. Can you say it again?
And you can't be employed by a public accounting firm doing those things, just like you can't be employed to do the practice of public accountancy, which is defined by an employer for more than one client. And then or you know, in a role that's not considered private, whatever we say before, right? It's really just trying to define, we know you're the CFO here versus you're here to do stuff for people. And you're kind of trading on your inactive CPA to do this, whether you're employed by a public accounting firm or a private
Does
equity firm.
a CFO do any of that stuff, right? Like the professional services of accounting, tax, personal financial.
Probably tax planning matters.
Okay.
They might,
Um,
yeah. And they might also prepare the tax return depending on the size of the company.
Yeah.
Absolutely. There is definitely stuff that overlaps with our definition of what public accountancy is that you would have a CFO do.
Time management advisory too, because that's all broad.
Can we
wouldn't
get there?
then-
Oh, go, okay,
So a person employed, what were you thinking about that person employed?
Employed to provide services that match the definition of the practice of public accountancy for anyone other than their employer, right? Because that's what we're saying in private. They're doing it for their employer.
Mm-hmm.
So, and I'll come back to you, Amanda. Angie and Beth, how about under that inactive, excuse me, under that inactive status, under 3, an inactive licensee may be employed by a governmental unit or private industry employer in which accounting skills are used or required to be provided. However, that we've got A, B, and C there already. You could put in a D that says the employer does not provide public accounting services to its customers. So that way, I'm a CFO of a manufacturing company. Cool. I mean, they're making stuff and shipping it. They're not providing public accounting services. But now I work for an entity that's just doing tax. And they're not licensed because they think they don't have to be. But it's a private industry employer because they're not licensed with the board, but they've got tons of tax clients, and I'm one of the cogs in that machine cranking out tax returns. If we added a D there that said that my employer has to satisfy A, B, C, and D being they can't be serving with public accounting services a bunch of customers, more than one customer, whatever, does that get us to where we want to be? And does that help with PE?
Does that cause a conflict by us saying that we're okay with inactive CPAs working for a company when they're not doing CPA stuff?
Yeah, that would be, I think that.
I wonder if there would be like a confusion there. I know it's a different section, but
Yeah, I hadn't gone there. I was trying to plug it. I was trying to put a finger in a dike, and I'm not doing it very effectively. And what you ladies are kindly telling me is, Jason, yeah, that's lovely, but there's a whole bunch of other holes. You need more fingers. Okay, Amanda, to you.
Really, I was just going to say kind of the same thing that Beth said.
Okay, Jake, I'm feeling, so here's the thing about my office. At one point, I was the only man in a tax department of about 16. And the ratios come up to now the ratio is like one guy to 2 or 3, I think to 3 ladies, maybe 4. And so I know when I need to just stop talking. Back to you, ladies.
Okay, so I think the idea, right, is like we can say. So, this takes it out of the 2 buckets too, right? Like if we were able to figure out a way to do this, we would just have the 1 bucket of saying like, if you are regardless of what you're doing, if you're an active licensee,
And you're gonna do this, you're gonna do public accounting for clients, you need to get active. And if you're not doing that, and we provide some examples, you can remain inactive, but have guardrails on that so it doesn't go crazy.
So it sounds like essentially, and thinking back to the providing services maybe only for your employer as a controller, right? It almost sounds like what we're trying to say is, as an inactive licensee, you can provide services, pretty much any services, for your employer, but not for clients. So it doesn't really
Yes.
matter what you're doing so long as it's just for your firm. If it's your own controller things or whatever, private industry, anywhere, you're pretty much your only client can be your employer. Don't phrase it that way, but you know what I mean.
It gets complicated because I also have, quite frankly, very uncomfortable memories. I don't want to say the name of the particular entity. This may have been slightly prior or at the very beginning of your time with the board, Angie, but I remember a case that involved an individual who was essentially under a restriction from our board. And this individual ended up essentially saying, well, I don't need to have an active license in order to, work for my employer. But that employer turned out to be basically a form of a temp agency.
right, yeah.
And through that temp agency, essentially, even though technically he was doing work for one employer, the very nature of the work is that through that employer, he
was doing the work for his
assigned out
employer. Yeah.
to multiple clients.
Yep. Wow. One bad apple.
Right.
Right.
Yeah,
And
that's
so
right.
it's I don't know how we capture that, but I think, do you feel like you have enough right now, Angie, to kind of get a sense of where the LRC wants to go with this?
I think so.
So a thought too, I mean, this is more about wordsmithing and I'm not getting into the weeds on it, but for some of these, I mean, we have so many exceptions we didn't have 40 years ago, right? Is there some way to put some of this out and then some extra A, B, C, D sort of things that help add some clarification without affecting the whole paragraph? Does that make sense? Because I mean, Martin, the example you use, it's not totally common, but it's not uncommon either. It's not the routine, but it happens regularly, by a small percentage of folks.
It's almost something about the work product that you do and who's using it, right? That's sort of the concept of like, if the work product is for your employer's use related to their own internal things, that's okay. But if you're providing it to someone contracted by your employer, that's not okay. But that's getting real detailed.
It is.
And if we don't use the right words, someone can find a way around that too, I suppose.
Angie, I see temple squeezing, mild temple squeezing.
Yeah.
Yes.
I mean,
I'll try.
Okay.
I'll put them together for it. The other thing that was that I won't be there on the 15th of August. So that's one thing to think about. So maybe this one doesn't come back to that. You know this, Martin. We talked about it during the meeting when we scheduled that. I have another board meeting that day.
Would you like us better?
I do. I mean, basically what I said was like, I can, as soon as that meeting is done, I can try and join you guys, but I can't
Yeah,
get
I
there.
remember.
Yeah.
Okay, so let's
Or we can move the meeting later that day, but because I'll be done with that meeting. But that's another topic. So
Okay. So let's move us on to the next topic, which is experience for PA licensing. And Angie put together, so right now you have to have 2 years of experience before you sit for the exam. And then provide an additional year of experience after passing the exam. What kind of experience should that be?
So the way that something happened, something got lost in translation in our rules for how, even though it was in the statute, it got missed in the rules. And so, but it's not a big deal because we don't have many PA licenses.
We haven't had anybody go through this in a while,
Right.
yes.
Yeah. So we just need to make sure we clean it up and put it in. And the way that they were doing it before, for at least for some of the experience, was that it all needed to be sort of like similar to what a CPA experience would be, right? Where they go through that same whole process. So is that what you like, obviously without the attest part of it?
Stupid question. Can we end the public accountant program and just allow the people in it to exist and then no longer allow people to apply new? They did that in Illinois. They had a registered status and they got rid of it, and anyone who had it could keep it, but it's no longer available. Because I'm just not sure it would allow you to practice in Oregon, but I think that's it. And that might be a good enough.
So just to be really clear, we could, I think that formally ending the program is a statutory change.
Okay. Yep.
I also want to be honest that inside this group and with the board, I've been, quite frankly, so far successful in convincing the board to not cut out the PA program. Okay. And simply because I like options.
Yeah.
I like options a lot, especially in this changing landscape, right? And I don't want to get off kilter here with respect to what Jason's trying to get through today.
Yep.
What I will simply say for transparency reasons, I would love to just focus on the experience question that we're trying to get through, but I also want to be transparent with the group that we actually have had a community college knock on our door and say, hey, we'd like to, train people to be PAs on that more experience-based pathway. What type of program would we need to design, right?
Okay.
And so it's an interesting one because I wasn't ready to, and I don't think that the board's ready to, because they seem to like options, right? To essentially completely throw out the possibility of having an experience-based pathway to do some level of public accountancy work, even if that's not a CPA license. There is no reciprocity, there is no mobility, there is no nothing, right? Mm-hmm. Because the PA construct does not work that way. But what's also in my mind here is that as part of the work that we did on Senate Bill 797, right, one of the things that kept coming up is there was, for example, a Salem-based firm where I had a conversation with somebody who I've known through committee work for a long time, right? And he basically said, there's this unlicensed person who's working in our firm who is essentially part of our core, and we're all fighting over who gets that person to work for us when we get a new assignment because she's that good. And that person, quite frankly, he said, would be has fantastic accounting skills and would be a fantastic CPA, but that person is not going to go back to school for 4 years and get a credential, right? And there is kind of like the subset of folks that quite frankly, if you go back to the original history of how CPA credentials were earned back in the very old days, it was all an experience-based pathway. There was no other pathway. And so I'm not sure that we want to throw this completely out the window, because especially with the way the profession is changing, and I just want to save that discussion for down the road when the board's ready for that. Right now, it has to be on Senate Bill 797. But I think for now, it's just the experience piece. But I will admit there is a bit of a broader topic there for down the road as to where we really want to take this.
Mhm.
But I think the interesting thing is this really what it is, right? Like, it's like that whole idea of like, and that was what I think kind of got lost in translation in our rules, is that like, this was sort of a way of like, the reason why this has so much experience requirements, right? Is that because the idea, right, is like you're getting all these, you're getting all this experience before you sit for exam, and then you have to get more experience after you sit for the exam, with the idea that like you're getting that, it's sort of in lieu of, but you still can't do a test, and you know, there's a couple like that stuff. Or audit. No, they can do it. Wait, Martin, remember I always get this wrong.
They cannot do audit under the
They cannot do
statute.
audit.
They actually can do work in the attestation and peer review area outside of audit work per statute.
The only thing
Mhm.
So what's in
they
rule?
can't do as an audit.
They
So that's
cannot
why I
do
wanted to
audit.
touch on the experience, right? Like,
Yeah. So I guess we'd want to just make sure that the experience would cover anything that they can do. They don't have to do all of it, but it needs to be in those categories. But we wouldn't
right.
want
And
audits.
what
Yeah.
kind of evidence of the experience do you want? Do you want it to be the same as what we do for like, is it more? Do you want more? Do you want it more sort of like rigorous experience? Or do you want it like, because of the respective, like, you know, this person didn't go to college, right? So that's not saying that you can't get the experience that you need, you know. So like, that's just like sort of looking at like, what do you want that experience to look like?
For the 2 years before, is that highly documented and codified, or do we need to do that too?
It has to be, yeah. So right now, and it's always been in statute that way. So it was always 2 years before you even can sit for the exam, you have to prove that you have to, before you can sit for the exam, you have to prove that you have 2 years of experience. And then after you sit for the exam and pass the exam, before you can get your license, you have to show that you have an additional year of experience.
And we haven't really fleshed out the 2-year experience.
Yeah,
It's like
and we
some-
haven't had any experience with this in probably 2 decades, right?
Yeah.
It's actually
Okay.
like it's in some parts of our rule, but not in other. It
Okay.
really is just like, so what I think probably makes the most sense, right? Like right now, is like what I'll probably try and do is pull all of it out from the rule and put it all in one place. But I didn't want to do that until I knew what kind of experience you wanted.
I mean, my instinct on this is why would we follow a different competency and experience pathway than we would that we've already established for the CPA candidates? If we start there and then just, see if we need to edit it.
Yeah, because the public won't know the distinction. They're going to expect the same quality of work on the things that the PAs can do, as I would assume.
Pretty much they can do a lot with a PA license in Oregon, as you point out, Beth, right? So I would think that from a strict public protection point of view, I completely agree that we should start out with the same competencies, right? And the only competency that I think we need to be able that we need to remove is audit-specific competency.
Absolutely.
Why can't we do that? Have them refer to the same competencies that are already in rule and say they fulfill competencies 1 through 6, but not 7. And they're signed off by a PA or a CPA, just like CPA candidates are, so that the process is the same. The experience requirements are the same, with the exception of that one, the test piece, nope, don't have to worry about that. Andrew popped on in person. Does that mean Andrew has a comment?
I've been here. I was just going
Well, I know you've been here, but now we can see your face and the cool, out the view.
No, I don't have a comment. I was just gonna say our last PAs that came on were in 2022 and 2019.
Okay. So
And they were
recent.
accidents, quite frankly. I
Still-
remember
Yeah.
one case specifically where somebody
They
applied
still
for
came on.
CPA licensure. No, they came on, but they came on not through the experience pathway, but they came on essentially applying for a CPA license and didn't quite meet for whatever set. I can't remember the exact reason. The standard for a CPA license, I remember that at least in one of those cases, it turned out that the individual really just wanted to work in the tax arena, right? And so we basically said, hey, you actually would qualify under the PA side, but you wouldn't qualify under the CPA side. And essentially, it became a resolution of somebody essentially switching gears and applying for a PA license, and that individual was happy with that. But as I understand it, right, we have really two very different pathways to PA licensure, right? Because one of them is education based and the other one is experience based. I don't think, it's not just, we have folks going for that are sitting in PA licensure based on an education pathway, not a, purely experience pathway.
Well, and kind of given what's going on, I mean, there's a whole thing going on in higher ed right now too, right? And so I'm curious to see if over the next few years, if we might see more interest there.
Yeah.
Which would be helpful for the profession to at least preserve that as an option to come in, right?
Yeah, and that's all I was trying to do is preserve options because I really don't know where the board and the overall CPA community is at in terms of what they would like as options. I don't know the specifics, but my gut instinct was let's preserve the options so we can at least have the conversation when we have room for the conversation, and then we go from there.
So the other thing on the experience side of it, right, is that we'll have to delineate out like, so you have the 2 years of experience that obviously has to be completed in the time frame before you sit for the exam, and then you sit for the exam, and then the experience that's completed for the year after is. So we'll just
Can I just throw out one thing? And this comes really more from my background in other professions, right? I want to just try this out at a more granular level, right? Since we're really having this, if you will, two-step structure, right? 2 years before you sit for the exam, 1 year after, right? At the risk of stating the obvious, when I look at this just from a regulatory perspective, right? You wouldn't have the same level of expectation of competency after the first 2 years of service, of supervision, getting ready for the CPA exam, as you would when you get the final sign off after year 3, right? So it's kind of, we don't, right now, with all of our experience stuff with CPAs, it's a one-time sign off saying, hey, this candidate has met the competencies, right? Here, we really don't have that luxury because it's coming in 2 phases. So I almost feel like, and I'm going to phrase this very simplistically, probably make your hairs grayer. Sorry, Angie, right? But I almost feel like it would have to be something like, okay, here are the competencies that have to be achieved at the end of that 3-year pathway, and that the 2-year sign-off is really something like certifying that the candidate has made sufficient progress toward those competencies, that the person signing off feels comfortable that A, they're ready to sit for the exam, and B, that they will be able to achieve after an additional years, these competencies that we require, because we can't require them to already have the same level of competency after 2 years if we're saying it's going to take them 3 years to get there. Does that make sense?
but then also too, with the NASBA, they apply to sit for the exam with NASBA, not
Yes.
with us. So did they submit that to NASBA?
That's well, short answer is that we can that we could I'm not exactly sure how that would work. We haven't really had that, especially since the CPACE transition, which is only about roughly 2 years old or 2.5 years old, to to NASBA processing this stuff. So I think we either have the choice of saying we're going to process those ourselves, right? Because it'll be a super low volume anyway, and it'll take us forever to train NASBA on something that they probably have very little experience with. Or we say, here is what you need to do. Here's what the forms need to look like. But I would probably prefer to just keep that one in-house.
But we wouldn't have an application for them otherwise, right? So then
Yeah.
they'd be submitting 2 applications. They'd be submitting it for an application for us to sit for the exam, and then submitting an application to NASBA to take the exam.
Yeah, which is what we've done before, right? Is that we would essentially provide the permission to sit, right? That's what we've done. That's what we used to do for everybody in-house. And then they would have to go to NASBA and say, hey, I have permission to sit, right? I now need to just register for the exam. And NASBA would simply accept that the board has said, hey, this person, meets the requirements in the state of Oregon to sit for the exam. We give them what's called an ATT, authorization to test, right? This is all stuff that we currently no longer do because it's all about CPAs where that happens essentially NASBA internally, and they only come to us with questions as to whether somebody meets the Oregon standards or not, essentially the borderline cases. Or not, because it's still us making the final determination. They're processing for us, but they're not setting policy for us, right? That's the way it's supposed to work. So we could easily carve out the PA piece. I actually, quite frankly, have knots in my stomach about trying to work with NASBA through that stuff. I think we would have to do an ATT process the way we used to do it for all of our CPAs. And this is not going to be a high volume deal. I think it'll be easier for us to do it in-house.
Okay,
Do you have what you need on that, Angie?
I think so, because we'll have to do a separate sort of like an application to the board and then an application. It'll be 2 applications.
Okay, I'm going to move us to the CPE. Again, 3 categories. 1, proration on staff request. 2, credit for community service. In other words, us here today on this committee. And 3, CPE for instructors for 1 and 200 level courses, because CPE is offered for participants for those courses, but instructors are limited to CPE on 300 and 400 courses.
Okay. So let me be the skunk at the garden party here for a second. There is essentially, whether we would like it or not, and whether it's on the agenda or not, a 4th issue that has entered CPE land across the country, really. This is not, me coming up with asking you additional things to do. And I just want to say in full transparency, what's happening right now across the country is rumblings of conversations that have to do both with deregulatory stuff, but also with, quite frankly, us being an outlier as a profession with respect to the amount of CPE that we require relative to other learned and complex professions, right? And so there is actually a real debate that's starting to happen about whether the profession as a whole should make adjustments in the CPE construct. Now, I just want to at least be transparent about that. I will also say this, given what we need to do here under Senate Bill 797, what I hope we can agree on at a super high level is that we should ignore that conversation for a while and just deal with the specific issues that Jason just outlined. But I also don't want to make you feel duped, because at some point, because this stuff is out there, it's happening in all the other states, it's going to show up in debates. The LRC is going to find out that there are these really fundamental conversations going on. I want to make sure you at least hear it here, right? Because I don't know yet how boards of accountancy, NASBA, AICPA are going to react to those conversations. They're complex and political. But for now, let's just focus on the 3 things that Jason laid out. for us in CPE land, but let's be aware that there are far greater rumblings than those three topics going on in CPE land.
Yes.
What is the proration question from staff?
In all honesty, Andrew, I need you to present that one, but I also want to just own that essentially, and I think this is really my fault and a lack of communication with me and with my staff. What we did when we updated the CPE rules last time, most of the stuff was helpful. And then there was one piece that we did that was intended to make it easier for us in terms of, because we had this really kind of weird, like 3.33 something proration piece in a rule, and it kind of was driving us crazy. And we thought we were making it simpler by just going to like a 3-hour proration rule. And then I basically heard from staff that essentially this may have been well intended, but it caused a whole bunch of problems. And so I'll stop there. So it's essentially, I want to just own that it's a little bit of a revisiting of a territory that we visited before, but I want to step out of it because clearly I messed it up big time when I was in there. And even though Andrew was there, I think we just pulled the brake too late and it kind of got into the rule. So Andrew, do you want to just kind of outline the pain that was caused, why it was caused, and how you're trying to fix it?
Oh, mute.
You're muted.
Thank you. In 2023, the LRC had decided they did not like unwhole numbers. And so they wanted to get rid of the 1/3 CPE requirement on proration and just make it even at 3. And so what that did was it created a 72-hour CPE proration for reinstatement and newly licensed individuals instead of the 80 required in other parts of the rule for renewal. This became issues with LC Vista, nationwide CPE tracking company, because we had 2 different rules that contradicted each other, and then also with NASBA. And we're still dealing with that on about a weekly basis when people are using their CPE tracking tool. So we'd like to go back and revisit this and change it. Washington, researching other jurisdictions, they do not prorate their CPE. But going down to California, they prorate their CPE in 20 CPE hour increments, which would be similar to how we prorate our active fees for newly licensed and reinstated individuals. So just be 20 CPE hours broken down by every 6 months, depending on their proration. And that would equal a nice clean 80.
So basically what you're suggesting is that we replace the proration approach from a monthly to a quarterly. And quarter is simply, if you're in that quarter, that's what determines how we calculate your fees. That's how we determine how we calculate your CPE. If you're in whatever, coming in the second quarter, you owe us 3 quarters, i.e. 3 times 20, i.e. 60 hours of CPE, right? And it's simple and clear,
It's a
right?
little-
60, 80.
A little different than that, though. If you come in the quarter, you're not on the hook for that quarter. It's the full
Exactly.
quarter. This is the way it's written. So if you come in the
okay.
second quarter, you just have 2 more quarters. You're exempted because you could come in on the last day of the quarter. Just
Exactly.
sorry, this is my super wonky world right here. But
okay, yeah.
just to share, we have hundreds of California CPAs, and this proration works really well for both new and reinstated.
Oh, I love that perspective,
Yeah.
Beth. So you're saying the California model has been working
It's
really
been great. It's clear. We know what to tell people. It's easy to track. It makes sense.
I don't know what we were thinking about getting rid of that third, because if you just, I mean, you basically have to have less. I like your California point. You answered my question because I was a little bit worried about what happens when you just tip into or out of a quarter.
Is there a way that we could make Jason happy and say, can we keep this discussion short for once and make progress on the agenda? And can we just say, does anybody want more discussion on this, or are we good with,
I
can
just
we
want to know
just
who's
do the
gonna
California model?
who's gonna write the edits to this, because I This is like,
Andrew volunteered already. He loves the
Okay.
California model so much.
if he's
You can
gonna
tell by
edit
his
the
face.
rules. Okay. So I just want to know, I don't need to touch these rules.
I'll submit him to you and Martin.
So I like the California rule. Anyone else or the California method on this particular item? Anyone have concerns about moving forward with that? Speak now. Hearing none. Next would be CPE for service on committees like this one, board committees. Thoughts?
That's available in some jurisdictions and others not. I don't see a lot of people taking advantage of it, but it's nice for people like Jason or Amanda who are doing the work to be able to get
Mhm.
credit. Are we recommending any sort of limit on the amount of credit?
Well, actually, Beth, I actually was hoping you were going to speak up because I didn't have a chance to really do a lot of research on other jurisdictions. So
Yeah.
if I can just pick your brain for a minute, right?
Yeah.
So first of all, can I make an assumption that this would, since we are, first of all, different states do different things on CPE, not just in terms of whether they allow this, but even whether they have things like a technical bucket versus a non-technical
Yes.
bucket, right? Some
Correct.
states just say all CPE is the same. There is no technical or non-technical
That is
bucket,
correct.
right?
Yeah.
Let's assume for right now that we don't want to do a wholesale rework of our CPE rules and start mucking around with our buckets very much, right? So
Yeah.
my first assumption is that in those states that allow this service, that is it considered technical or non-technical? Do you know?
Well, usually they define the committees as technical committees, and then that solves the issue. So it's like,
Okay.
are you on the Board of Accountancy, or if you serve on a technical planning committee for a state society? So they frame what can be counted by putting it.
That kind of makes sense because BOAC's deep in the rules, board is deep in the rules, peer
Yeah.
review oversight committee's deep in the rules, LRC's deep in the rules. So it
Yeah.
kind of makes sense to me, just to be really clear. Can we
Mhm.
just ask that question first? Are folks in generally comfortable that if we give credit, that we explicitly do it in such a way that it would qualify toward the technical credit?
I am.
Yes, and we have some history on that too, plus a limitation from, it's sort of somewhat related. There used to be something for the legislature.
We deliberately took that out because it seemed
know.
like a credit that was written for one specific person
Well, it was, but
into the rule.
we have some ease in kind of looking at what some language could look like for ourselves, but there was a limit on, that's where I'm getting towards. There was a limit on the number of credits.
Yeah.
Yeah, we had a credit language in there that basically said you get to have credit if you serve on the Ways and Means Committee in the Oregon State Legislature, which was like, okay, if that wasn't written about one specific person, I don't know what was.
Well, I understood that. So I have no objection to this. And as long as I think it would be important to put a limit on the amount of credit.
Similar to
I mean-
instruction, 50% max.
Yeah.
That would seem a lot to me, bluntly.
Yeah. Generally, it'd be like 10 credits is
I
what
was
they
gonna
would.
say
Yeah.
8 or 16, maybe.
Yeah.
So
I'm indifferent on a limit because most people who participate in committees are keeping themselves up on technical content too. So it's something that's rarely documented.
To me, it's about the optics.
So may I make a proposal that doesn't need a vote? These committees for the Oregon Board of Accountancy are technical CPE, allowing an hour for each hour, or a part hour for each part hour in committee meetings, with a maximum credit per renewal period of 10 hours. Any concerns?
No, you just may want to, in our rules, include what documentation is accepted, because that can be, is it a letter from the committee confirming service? Is it an agenda?
Oh.
I'm just telling that to.
Can I simply say that because they're board committees, the board is in possession of information as to
That's
who showed up
right.
or not, right?
Yeah.
We're not talking about an activity that they do external from the board. So
True.
actually what I would like to do is basically say that they wouldn't have to submit that documentation because we already know.
True.
I would say saying active participation. I'm just thinking about like our
Oh, yeah.
committees, you can be on the committee and it's complimentary, but if you're not participating, if you're not active, then you're not
Mhm.
eligible for that complimentary. And like we've had to be very specific about that over the years. I think to specify active
Mm-hmm.
would be important.
So they're not just appointed, but if they never show up and then
Yeah.
claim,
Correct.
It has
CPA.
to be participation in
Yes.
committee meeting,
Participating
not,
in the
yeah,
committee meeting.
Yeah,
not,
but
you
even
don't get 10 credits for being on the committee.
Yeah, even participation. Okay, what does that mean? I think you have to be tight on your definition.
Mhm.
So,
Yeah. I don't think we need to worry too much about that because again, the board has the records of who was attending the meeting.
well, and that's I'm not worried about that. I'm worried about the opposite side of folks that miss a lot of meetings, right? I mean, then how do you do? I'm just saying we've already worked on that on a complimentary basis for conference registrations where we had to have specificity about how you actually participate, attend, etc. I just don't want to see it I don't want to see a bunch of questions come out of it. Because they can. People are not blatant. They're just busy, right?
So what I'm hearing is it would be for, if I'm attending this meeting, I'm going to pick on Ray. Ray would not receive credit for this meeting.
Correct.
Jason would.
Correct.
Must be present to win.
Yes.
But again, I'm just saying it because of the optics. There's a lot of external stuff that goes on these days.
Yeah.
People need to be active status.
Mm.
'Cause
Oh,
right
you
now
can't
we
use it
allow
for an.
retired and inactive
Ah.
to be on committee.
Right. I'm not saying status.
No, active
Oh, I know what you
participation.
were
Active
meaning. I was just
participation.
asking this as a
I'll leave-
follow-up.
I'll leave it up to you to wordsmith, but I think you kind of get the tone, right? You can't just be signed up. You have to be involved.
And quite frankly, we may want to, I think I just heard Andrew say this, and I'm not sure everybody heard it. I think we have some pretty restrictive language right now that if you're inactive or retired level licensee, that you're not eligible to be on a committee. Is that possible? Because if that's true, we need to fix it because we've had, number one, and I'm trying very hard not to look at Beth here, and Sherry, non-serving on committees.
Right.
So as my gaze wanders away from Sherry and Beth, right? I also want to gaze away from Ray, who has been explicitly invited by the board to serve and do an incredible amount of work for us on LRC, even though he is a retired level CPA, right? So I do think that it will be important for us, to the extent that we have those restrictions in there. I would prefer to loosen those if that's cool with folks.
Yeah.
I think that's smart because you're going to have other topics over time where you may want some external experts.
Yep.
I can think of a variety of things that just kind of out there.
So I'm going to transition. Oh, Amanda, then I'm going to transition this based on external experts' comment. Amanda?
I was just gonna say, based on as far as the documentation and support side of things, Andrew, is there something that I mean, is what we're talking about here? Does that give you heartburn as far as just somebody being able to kind of on the renewal application say, "Yep, I participated in this committee and I'm claiming this many hours," and on the verification side, or kind of, would you need more from us on that?
No, we're a small jurisdiction that's easy to track.
Okay. So let me take that in. And frankly, if there's always a member of board staff at these meetings, you could simply send out an email at the end of the meeting saying, "Thank you for your attendance at this meeting. It's an hour and a half of CPE, period. There's your documentation." From board staff.
That's a lot of extra.
It sounds like something Quinn would love.
Okay, I'm going to move us on. Don't get me in trouble with Quinn. So
Oh God.
with the reliance of experts comment, I would respectfully like to move the CPA for instructors discussion until next time when we have Ray with us, because I think his input on that is going to be important.
Paul.
Okay, so that moves us to peer review, disciplinary authority. Let me tee this up and with Angie making corrections. So currently, as I understand it, if we have a firm has a failed peer review, the board can go in and say, golly, we probably ought to look at this and do their own investigation. The question is, do we want to, in rule, give the board the ability to say, they failed their peer review, that we're just taking action?
Right, so currently if they fail the peer review, we would have to go and investigate, right, and prove the underlying peer review violations. So if you wanted to say, you can't just discipline them with the way we have it structured right now, we can't just say like, you failed peer review, therefore you are disciplined by the board. It has to be, we have to show how they failed the peer review. And so basically what the statute allowed, right, was like we can put in rule, you know, one failure of peer review, you know, not a violation necessarily, but like two fails or whatever, however you wanted to structure it, right? So I actually came up with a rule a long time ago, unless I can try and dig it up. I don't know where it is, but basically it was sort of looking at that of like being like the board can, and it's, you know, decide to just purely just for the failed peer review, discipline you, and then put you on whatever they wanted to do. And it just gives us more sort of like control over, because what happens right now, right, a lot of times you'll get like somebody with like three failed peer reviews, you know, and then there's not like a lot we can do unless we just go in and actually, you know, they're dealing with the peer review people, right? And they can, you know, I guess potentially get kicked out of peer review and things like that can happen. But this would allow us to actually say, okay, you know, like sort of like on top of that, right? You're either going to get a civil penalty, you're going to be, you know, revoked, you're going to be just purely for the, without having to prove the underlying violations of peer review itself.
So I think what you're trying to say is that we could write a rule that would allow us to say, for example, something like, if you have a consecutive fail that is essentially pertains to the same, if you will, issue or error on the initial fail, because sometimes you can have consecutive fails that are about completely different things.
Okay.
Right? That the board may discipline just based on that occurrence alone, or based on failure to comply with the peer review process
Right. Yep.
itself. And that would essentially be an ability for us, not a must, not an automatic trigger for discipline, but simply the authority that the board can consider discipline based on that occurrence.
Right. So it would be the board may discipline if blah, blah,
Yeah.
blah. Yeah.
So, and I'm going to throw something out. I'm starting to drive us just a little bit because I want to be careful with people's schedules and time. What I'm hearing is, should we put in to rule language that says, if you have, and I'm picking numbers, 3 peer review failures, so that's a 9-year period.
I would say 2.
Okay, 2. So over a 6-year period, peer review failures on the same issue, the board may impose discipline. Andrew?
Failure or also passive deficiency?
Have we done any vetting to see if we're like plowing a new field here, or whether there's already something that is tidy and I don't want, I don't
I'm
want, dra-
unfamiliar.
huh?
Yeah, I'm unfamiliar because it's always been passed for us, so I haven't read any other state laws on it, state rules.
I
Just write
really,
a rule to be like CLA.
I guess.
We've
I
always passed too.
No, you don't know, Jason. You don't know if you fail, you never look at it, right? You just
Exactly.
you,
All I
don't
know
know.
is we pass and that's what we do. And I have awesome audit partners and yeah.
Yeah.
And I'm not suggesting that we drag things out. I
Yeah.
kind of like that language that you were using. I think the board should have authority to do things, but I also want to make sure that we're not like this outlier in the environment. I mean, a few times that we've been outliers, it's been very painful and it's caused us some negatives. And I'm
Good
speaking,
question.
I'm speaking
How
as
do
a,
we,
I don't think we'd be outliers, but I think we can do some additional research on that while we draft up the language.
and
Okay.
one last thing, Martin, I would volunteer, since I'm on the National Peer Review Committee, to ask a general question and see if we could get any feedback that I could pass to you. It would be informational only, nothing more. And then, of course, the committee would put their perspective on it. Or
Is
say
that
no.
AICPA peer review committee?
Yes.
Okay.
Yeah, national committee.
Amanda?
Yeah, and then so if we're giving the board essentially the ability to take action, disciplinary action based on the findings of peer reviewer, that seems to put a lot of power in the hands of the peer reviewers. Is that something that we're comfortable with?
I think that's what we were thinking too, right? Because it would be,
And that's why I went 3. And Amanda, I have the same twitch. If the board feels uncomfortable with TKW because of something that our peer reviewer has said, okay, I'd like the board to come chat with us. Rather than, oh, your peer reviewer said that you haven't passed this, so there must be something wrong.
Yeah, it's definitely a hard one because I see why you would want it, and I also see the law of unintended consequences that I think one of our prior speakers here just alluded to. In the unintended consequences, will peer reviewers shy away from issuing a second, consecutive fail if they know that effectively that opens the door to potential discipline by the board, and then it kind of may move things under the surface that we would prefer not to be under the surface, right? So there is a little bit of that push-pull.
Well,
so maybe you just do it as like regardless, like that, don't even say consecutive, you say the board can discipline for a failed peer review and just leave it at that and let the board decide what they want to do with it. I mean, like whether or not they do it or not.
my sense is if someone's having some real issues, you probably know about it for other reasons.
Yeah, and I'm uncomfortable with a one fail and the board can take action. That concerns me. So
This, to me, this topic is not a short topic.
it's
Yeah,
not.
it needs a bigger conversation.
It deserves some research too, I believe.
So let's have Sherry make that reach out, get more data in, and put this on your list of things to think about. And I cut you off, Beth, not intentionally. I cut you off, Beth, not intentionally.
Oh, no, I'm so sorry. I have a problem because I have a meeting scheduled right now, but I know we're at quorum and I don't want to leave if we need to vote on something.
Oh, we
I
don't need to vote, but we have to end the meeting regardless. So
Yep.
Okay.
So we've got, quickly, Sherry.
Really fast. Peer review conference is coming up in 2 weeks. I will reach out. In the meantime, I'll also ask a few questions of the experts because they're all going to be in the room and then I will move things to Martin.
Perfect. So we got through a bunch of things today. We've got a couple of holdovers. Since we are at 11:02, our next Laws and Rules Committee will be held Zoom only, August 15th from 11 to 1 o'clock Pacific time. I'm now adjourning this public meeting of the Board of Accountancy Laws and Rules Committee. Time is now 11:02 a.m. This has been recorded. Thank you for all of you who have participated and been very engaged in the discussion. Staff, please terminate the recording.
Martin,
Thank
can you